I will pay some amount, but if there is a perjury proved, it should be refunded, my lord. Or
If orders will not be passed. Please, Mr. Counsel, please understand what is the scope of this writ petition, what orders the court can pass. Everything your client wants can't be passed. You are before this court questioning an order of maintenance, whether it is right or not. According to you, it is not right because her stand with regard that she voluntarily left, she deserted you, and she is not entitled for maintenance under section 125(4). That's what is your case.
Yes, ma'am.
Now, that cannot be decided. Now, she has filed the petition seeking the divorce on the ground of cruelty.
Yes.
She has her own reasons to leave the home, whether you have thrown or she has gone on her own. That will be decided by the court in the MC proceedings. Till such time, you cannot say that she has voluntarily left. She is not entitled.
I am not saying, my lord, she admitted. I am not saying, she admitted.
She left. She has her own reasons to leave the house.
No, there is no sufficient reason. My lord,
Can't be decided.
at least the IA order can be disposed of in accordance with law.
How can it be? No, this is notice has to go to her, isn't it? Notice has to go to the respondent.
No, at least this petition may be disposed of, giving a direction to the trial court, dispose of the IA and main petition in accordance with law. That's all I'm seeking, my lord. That's all. IA order, if they can pass an order.
When is this? The already court records in WP number 2143 of 2024 has directed to dispose of the matter within 3 months, and the time to be stipulated has been elapsed. Therefore, both the petitioner and the respondent shall cooperate. That's what is.
I am cooperating with the maintenance.
The court will take care of it. How many orders court has to pass?
No, in execution, at least let them hear me and then pass an order.
Where is the execution order?
No, they are not hearing me. That's my problem. At least.
You just can't ask, please understand. If the court has to pass, there should be something before the court. The order impugned is an interim maintenance.
Correct, my lord. Yes, my lord. Agreed.
With regard to anything, if the court finds that something has to be done, the court will pass some order. What you are seeking is not with regard to this. Why would the court say something about something which is not before the court?
No, I am only challenging based on the perjury, my lord. She made a statement in her affidavit.
Dismiss your case because this court is not going to decide on this order impugned, and that's not a ground. That cannot be a factor to be decided. The fact that the perjury as you are projecting before the court.
Much obliged, my lord. At least give a direction for a fair hearing. That's all I'm asking. Fair hearing on execution petition. Let the court pass an order. And then
you question the execution proceedings.
I have questioned the execution proceeding only.
Where is that?
A1 page number 42. 42, my lord. Execution proceeding itself is being challenged because the trial court is not hearing my IA in accordance with law.
Please come to 42. 42 is. What is 42? 42 is a petition.
Yes, ma'am.
Under 125(3).
Yes, my lord. Yes.
Then come to page number 44. What is 44?
That's a maintenance petition, my lord.
Correct.
Yes.
That is what is impugned before this court.
No, impugned order is A1.
How can you? Where is the order?
No, I'm actually seeking a quashing of this, but at least pass an order, my lord, on to hear me in the execution proceeding. That is what my difficulty is. It was posted for objection and suddenly.
Please tell the court where is the writ petition prayer. Come to the prayer.
Okay. Yes, ma'am. Page number 38, my lord. Issue a writ.
Yes.
Issue a writ of certiorari or any other appropriate writs or orders or directions or any of them to quash the petition criminal miscellaneous 1077 of 2024 filed by the respondent under section 125(3) of CRPC pending before 6th additional principal judge family court Bengaluru. The next number A1. My lord, I'm only seeking
the petition is filed seeking the following prayers. Then counsel the petitioner had advanced documents submitting that the wife has made false statement and is guilty of perjury, and it is submitted that the court is not considering all those the application that is filed by the petitioner. and filed by the petitioner. And he also is now, by virtue of this petition, he seeks a direction to quash the criminal miscellaneous 1077 of 2024, where the wife had sought to issue a final levy warrant against the husband towards the recovery of the amount of rupees 7,20,000 in the best 7,20,000. Next paragraph. An order was passed in criminal miscellaneous number 654 of 2021, wherein the court had granted maintenance of an amount of rupees 20,000 to the wife. That remains unchallenged.
We challenge, my lord.
Where?
It's not listed yet.
And you here it is not. Till now,
Yeah, it is not. That matter was not heard. It is challenged. Last. I filed it on the last day of before vacation.
when
my
is the
lord.
order passed?
This order was passed in 2024, my lord.
So once they filed once the warrants are
we
issued,
filed RPFC, my
after you
lord.
submitted that, questioning the said order, interim maintenance, how can you file RPFC?
No, that is what we withdrawn that, and then we refiled.
Submitted that interim order, the order of maintenance is questioned before this court, and the same is pending consideration. Then counsel submits that as she has committed perjury, the proceedings have to be quashed, and she cannot recover the amount. Next paragraph. The entire submission of the counsel for the petitioner appears to be that the wife had stated that she voluntarily left the husband at one place, and at other breath, it is stated that she has been egged out of the house. According to the counsel, this all amount to the misrepresentation and amounts to perjury. As such, she is not entitled for maintenance. Further, when she has voluntarily left, in view of section 125(4) of the CRPC, she is not entitled for maintenance. Full stop. These submissions, the court is not able to appreciate. The MC is filed by the wife seeking divorce on the ground of cruelty. And according to her, she had no reasons to leave the home. When she files an application for maintenance, at this juncture, the court cannot give a finding that she has left the home. As she has left the home, she is not entitled for maintenance. And section 125(4) to consider the scope of 125(4), this is not the appropriate stage, and as such, appropriate stage. As such, the execution petition that is filed and which sought to be quashed by way of this petition, that is criminal miscellaneous 1077 of 2024, is not permissible, and this court finds no reasons to interfere. The trial court shall decide the miscellaneous 1077, criminal miscellaneous 1077 of 2024 as expeditiously as possible, giving opportunity to both the parties. Next paragraph. This court is not proposing to issue notice to the respondent as no adverse or orders are passed against the respondent. Next. Yes.
14, please, my lords. I appear for the respondent.
Why the screen is nothing is coming? They should have done it by the time the court starts. Yes.
Please, my lords. I appear for the respondent.
No, we'll do it. Let me hear that. Yes, 14.
14, please, my lords. I appear for the respondent.
Yes. You file your objections to the IA?
My lords, my only concern is that, my lords, they have sent me an unnumbered petition, my lords, without any annexures. My lords, they may be directed to, my lords, to hand over a copy with all
You
the
appeal
annexures.
whom?
My
You are
lords,
his colleague? Oh, no representation for the petitioner for dismissal tomorrow.
this
Grand
is for the
counsel, the
second time.
respondent submits that the papers, all set of papers are not served on him. Next.
Then number 15,
Date.
Pair Lingraj.
Yes.
My lord, like to appear for petitioner, my lord.
That-
This is the husband petition, my lord. Against the husband petition, my lord. Interim application had been filed by wife, my lord. And considering the same, my lord, the trial court has ordered to give interim maintenance.
It's not served in this.
My lord, earlier, my lord, initially RPFC has been filed, my lord. Subsequently, it was converted on repeated,
Notice has to go 2023 matter.
my lord, my submission, my lord. Now, order to,
Can't stay anything
for
now.
for a moment, for a moment. Trial court ordered to pay 10,000 each to children's, my lord.
How many children?
2 children's, my lord.
So 20,000 is ordered.
20,000 has been ordered. My lord, the petitioner is an veterinary doctor. Wife is an assistant professor in a engineering college. My humble request, my lord, now she is drawing 41,000 rupees, my lord. The wife is drawing 41,000 per month.
How much he is drawing?
My lord, he is drawing net salary is 70,000. My lord, age-old mother, and also
Where will the
paying
children
rent.
go?
And also, for a moment, and also, so far as second child is concerned, my lord, paternity is under challenge. Application has been filed before trial court. Same has been rejected, and the case is pending before writ proceedings, my lord. Therefore, my lord, now I am depositing 10,000 for one child, my lord, before execution court. My lord, my humble request, my lord, let it be made that as a 50%, my lord. I am paying 10,000, my lord. Now she is maintaining paying another child, my lord. Therefore, my lord, my humble request, my lord, kindly.
Let her come, let her come. If you want to take out hand summons, please take hand summons. Or else the petition is permitted to take out hand summons on the council, appearing before the respondent before the trial court. We shall file a memo to that effect. In addition, the court notice
Please,
list this matter after 2 weeks.
Then
Yes.
number 16, Aditya D. Petitioner.
Chair for the petitioner. Lord, the petitioner has been evicted from the premises, my lord, and the
My lord,
respondent wife is
I would like, with the honorable court's kind permission, my lords, beg to appear for the respondent, my lords, in this matter.
Yes. Yes.
My lords, the writ is not maintainable, my lords. Preliminary objection, my lords.
What is the impugned order?
My lord, the impugned order is at page number 66, my lord. IA filed by petitioner under section 19 and section 23
How
of
a
the.
writ petition will lie against this order?
Please, my lord. An appeal has also been filed, my lord.
Then,
Please, my lord. I'll exhaust my remedies before the appellate court.
yes, the writ petition is filed. First of all, how is it numbered?
I filed
The
NOC
petition is
Wakala.
filed. Seeking to quash the interim order passed by the Judicial Magistrate Traffic Court 1 in criminal miscellaneous 04 of 2023 dated 30/8/2024, directing the petitioner to remove himself from the shared household till disposal of the petition. Land counsel appearing for the respondent has raised the objection with regard to the maintainability of this writ petition. Land counsel for the petitioner submits that already they have preferred an appeal against the impugned order. In that view of the matter, the writ petition is dismissed, giving liberty to pursue the appeal that is pending.
Much okay.
Then number
Highly
17,
obliged, my lord.
17, Udaya Prakash.
Beg to appear for the petitioner. Husband, my lord. 125 subsection 2 order, my lord, on IA number 2, grant of interim maintenance.
How much?
Total 15,000, 10,000 to the wife, 5,000 to the child.
What is your income?
My income, I mean, I have not filed a statement of affidavit is not filed, assets and liability is not filed. According to the petition, it is 70,000 is what is shown.
Then what is the difficulty to pay this amount? What's the difficulty to pay
So it is not
15,000?
70,000 is what I was told. The two contentions which is taken is,
No, that's why I'm asking you, your instructions or how much is
my
earned?
instructions is it is around 40,000.
Even if it is 40,000, 15,000 can't you pay to the wife and the child?
I mean, a child, I am not coming in the way, my lord. I don't want to
So
say
why,
anything. But
according to you, the wife?
according
is
to me,
earning?
the wife is already earning.
What is she doing?
She is working as a, it has been contended, my lord, at page number,
Can you pay 10,000 and arrears at 10,000?
she is working in Devas Maharshi Kadi Reshma Shilpa
That's
Sangha.
what, we'll say, we pay 10,000, arrears at 10,000. Then counsel for the
Fair.
petitioner submits
Fair.
that the family court has granted maintenance of an amount of rupees 10,000 to the wife and 5,000 to the child. It is the case that the wife is earning and the court, without considering the said aspect, has granted the maintenance. Considering the submission of the counsel, they shall be stay of all further proceedings on the ground that, on the condition that the petitioner shall continue to pay 5,000 to the wife and 5,000 to the child, and the arrears also at 5,000, arrears at 5,000 within a period of 8 weeks from the date of receipt of the copy of the order.
Already,
And continues to pay 5,000 to each by 5th of every succeeding month. The default to pay the arrears within 8 weeks or the maintenance by 5th of every succeeding month. The order granted by this court stands vacated. Petition is permitted to take out a hand summons on the counsel appearing for the respondents and shall file a memo to that effect by
please.
16th of June.
One submission. I'm told already 2.5 lakh is already paid to the,
No, if any.
if any, that may be.
Arrears, if any.
If any,
And shall file a memo to that effect by 23rd. Even if he fails to pay file the memo, and even on that ground also, the stay granted by this court stands vacated.
deeply.
Yes, next.
Cell number 18. Syed Ibrahim.
Yes. No representation post after post on 18th of June. Yes, 19.
Cell number 19.
My Lord's wife's petition, my Lord's
Palazzo.
petition seeking enhancement of interim
What
maintenance.
is
My Lord's, there is a connected matter. Husband has filed a petition.
this?
My Lord's, it
Is
may-
already there.
Yes.
Post along with so and so.
Along with number is
Next week.
My Lord's,
Yes.
date may be given, my Lord's. Date.
Date, they'll give the date. Next week.
cell number
20.
yes. Cell number 20. Anjan Kumar BN.
Petitioner in this case, my lord. My lord, it is 128 CRPC proceedings. 128, 125 CRPC proceedings, my lord. Where, my lord, after the service of the notice, this petitioner is the husband, my lord. After service of the notice, my lord, he has filed the application, my lord, for returning of the petition, my lord, since the jurisdiction is not comes to Mysore court, my lord. My lord, may I kindly see the annexure,
Who has
G and
filed the
H.
MC?
not MC, my lord. 125 maintenance petition has been filed by the wife, my lord, against this petitioner, my lord. Lord, after service of the notice, he has filed the application for return.
Court has no jurisdiction.
Yes, please, my lord.
Then
Lord.
what did the court do?
My lord, the court has dismissed the application and now proceeding with the matter, my lord.
Why, according to you, why the court has no jurisdiction?
My lord, may I kindly see the annexure G and H where I have produced the Aadhaar card of the both parties, my lord. Both are residents of Mandya district, my lord. But the case has been initiated before the Mysore
What
family
is the
court.
finding of the court on this?
My lord, the court says that the petitioner has produced the rental agreement stating that she is the resident of Mysore. On that basis, the court has considered,
She can't shift to some other place.
of course, my lord, but even if the rental agreements,
We'll see. Take out hand summons.
please,
Then
ma'am.
counsel the petition is permitted, take out the hand summons. And if the memo is filed by 17, this is matter on 18.
Please, ma'am.
Yes, 21,
21. Suraj Shinel.
no representation. This is the matter on 24th of June. 22nd,
Cell number 22.
same order. Same order.
Cell
Yes.
number 23, Nehru P.
Same order. 24 is adjourned. Which one? Next.
Cell number 24 urgent, cell number 25, 25 urgent, 26. Santosh R. Nelputri.
Petition.
26,
Husband's
25.
revision petition, my lord.
There is a counsel for the respondent. Counsel for the petitioner is present, no representation for the respondent. This is matter day after tomorrow. Case 27.
Cell number 27,
There is no petition in this case, your lordship. Petition is the husband, my lord. I have challenged in the order
27,
date.
Harish Kumar.
Challenging the order dated 19/2/2025, my lord, passed on under section 125 of the CRPC, your lordship. The wife and child has filed the case against me, my lord. Kindly see the page number
What is the
12.
amount granted?
My lord, 8,000 per month, my lord. He is a coolie, my lord. I have produced, he is a coolie, my lord. He is working as a coolie, my lord.
8,000 per month to both wife and daughter.
No,
wife and son.
only child, my lord.
Then what was the
Against,
material?
against-
What
Madam?
was the material before the court with regard to your income?
My lord, they are not produced any document to show.
Please come to the
Kindly see the
discussion.
page number, my lord. Page number 16, my lord.
Yes.
The respondent has stated that he is doing a coolie work and earning 15,000 per month, which is contrary to the admission given by the respondent during the course of cross-examination, wherein specifically
Where are you
admitted that.
reading?
Yeah, admitted, page number 27, your lordship. Working as a mason, your lordship.
1 minute.
Mason. From the conclusion of the court. And she has not produced any document to show that,
And earning rupees 15,000 per month.
yes, your lordship.
Uh,
According to the petitioner,
Which is contrary to the admission given by the respondent during the course of his cross-examination.
yes, sir. My lord, according to the petitioner, my lord, he is getting only 15,000, but if
No, no.
coolie work is,
No, you said coolie,
sir.
somewhere else you said mason.
yes, sir, but he is having the old aged mother is there, my lord.
No, that is a different aspect. Now we are on the point, what is your occupation and what is your income?
But mason, my lord, every day is working is not available, my lord. Every day you work,
That's for
definitely
you to say.
it is
That's
25, my lord.
That's for you to
But
say.
by
You
oversight
can't-
admission, my lord, he is a coolie, my lord.
There won't be.
Mason
the-
is a coolie, my lord. So,
Yes,
kindly-
how much you're going to pay?
my lord, I am ready to pay 4,000, my lord. 4,000 per month, my lord.
It's only
He is a
for
coolie.
it's only for the son.
Son, my lord.
How old is he?
7 years, my lord. 7, 8 years, my lord. And my lord,
Please come. The present revision is filed, agreed with the order dated 19 February 2025, whereby the court had granted maintenance of an amount of 8,000 to,
my lord, by oversight, female child anta order. It was order passed in female child. They are filed female child, my lord.
Oh.
But this is a male child, my lord.
the granted an amount of rupees 8,000 to the son per month. And it is also ordered that there shall be enhancement of 5% in the awarded maintenance annually from the date. Land council submits that is earning 15,000 and the court had granted 8,000 towards maintenance. It will be difficult for him to maintain himself and also his age-old parents. Considering the same, there shall be stay of all further proceedings on the condition that he shall continue to pay an amount of rupees 5,000
My lord, 4,000, my lord. He is a coolie, my lord. 4, my
5,000.
lord. Kindly humble request, my lord. 4.
by 5th of every succeeding month, and the arrears at 4,000 you pay. Arrears at 4,000 by within 8 weeks. 8 weeks shall be paid. Default either the maintenance by 5th of succeeding month or the stay granted by this court stands vacated. Notice to the respondent.
Cell number,
Yes.
cell number 28, preliminary in B group, Victor Manoharan. petitioner.
Yes.
Yeshuri, respondent served.
Notice is served.
Served under.
It's a minor child, my lords, born out of alleged rape, my lords, has filed this petition, my lords, seeking maintenance. And 3,000 rupees maintenance had been ordered, my lords, that I am challenging.
And what is the material on record to show what is the income of the father?
He's working as an headmaster, my lords, and when I filed this petition, my lords, he was dismissed from service. And later on in 2002, my lords, he was reinstated back in service. And he had been paying this amount, my lords.
He has been paying.
He's
3,000.
paying the maintenance.
What
my
was
lords.
his? He must have retired by this time.
My lords?
He must have retired by this time. What was his age, as on the date of the petition?
Child, my lords, when
Not the child. Father's age, 42 years, as on.
as on the date of filing of this petition, my lords.
No, this petition is filed by the father.
Father. No, petition before the trial court has been filed by the minor
Before this court is the father.
father, my lords. Not the father, my lords. That alleged rape, out of that rape, my lords, this child was born. Against this, my lords, a mother of the child had filed the petition seeking maintenance for the child. And only on the ground that DNA report has come positive, my lords, and that the DNA report was not challenged, maintenance is ordered, my lords. But in the criminal case, my lords, he has been acquitted.
₹3,000.
Please, my lords.
And what do you say about the DNA report? That is unchallenged.
Unchallenged, my lords.
So whether it is rape or otherwise, he is your child. So you have to pay maintenance. And that to 3,000, and
No,
you being
because
the
it's
headmaster.
a remote area, my lords, 3,000 has been ordered, my lords. It is stated in the order, my lords.
Will not interfere with this order. Please come. Agreed with orders passed in civil criminal miscellaneous number 95 of 2016 dated 6 December 2018. The petition is before this court.
Please.
The petitioner is before this court, whereby the court had granted maintenance of an amount of ₹3,000 from the date of petition until passing of the further orders. The respondent herein has filed the petition stating that he is the son of the petitioner. It is his case that his mother and the petitioner were residents of Bovi Palya village, Sita Kallu Majare. So and so, look at it. Their relatives. And on 21/10/2012, when his mother was alone in her parents' house, the petitioner herein came to her house and has committed rape on her. And she had intimated the said fact to her mother, relatives, and elders of the village. She intended to lodge complaint against the petitioner before the concerned police station. And in view of the panchayat held in the village, she had not given the complaint. And even in the panchayat, he has agreed to marry the mother of this respondent, and he has also received ₹1 lakh from the parents, from the grandparents, towards marriage expenses. But later, after continuing relationship with her, he refused to marry her. Later, when he refused to marry, she had lodged a complaint on 26/8/2013 and it was registered in crime number 233 or as a crime number 233 of 2013. And after investigation, police have filed the charge sheet. It is a case of the respondent that the father is earning an amount of rupees, is working as headmaster, earning an amount of rupees 30,000 per month. A DNA test was done, and as per the DNA test, as the same was positive, the court had granted maintenance of an amount of rupees 3,000. Next paragraph. When counsel appearing for the petitioner submits that in the criminal case that is filed by the mother of the respondent, he was acquitted. It is submitted that the court, when he is acquitted in the criminal case, all the more it strengthens his case, and the court ought not to have granted maintenance to the respondent. It is submitted that the order needs to be set aside. Further, it is also submitted that as per the order of the court, he is continuing to pay 3,000 to the respondent. Next part. So notice is served on the respondent. No wakalat is filed on behalf of the respondent. Next part. Having heard the counsel for the petitioner, produce the entire material on record. The DNA test shows that the first respondent is the son of the petitioner. It is also an admitted fact that in the criminal case, the petitioner is acquitted. In the criminal case, the burden of proof is on beyond reasonable doubt, whereas in this case, the DNA test reveals the relationship between the petitioner and the respondent, and the purport of the and the petitioner has a responsibility to maintain the respondent. Trial court considered all these aspects and rightly granted an amount of rupees 3,000. Mere acquittal in a criminal case cannot be a ground for this court to disentitle the respondent from having the maintenance. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed. Next.
Cell number 29, S.A. Vajid, Raghavendra, KN.
No representation. Let's this matter on 7th of July.
Cell number 30, TN Avin, TH Avin.
Yes, this also say.
Cell number 31, 31 adjourned, 32, Sharat Gowda GB. 32, Sharat Gowda.
Petitioner, kindly withdraw the petition right now. The matter is settled, and the petitioner.
Give a memo.
Yes, my lord. I'll file a memo.
You have filed.
I have to file one.
You can pass on. No, they want to withdraw. Take that. Memo is filed stating that the matter is settled. They want to withdraw the petition. Accordingly, memo is taken on record. And the petition is dismissed as withdrawn. 33.
Cell number 33, Dheeraj, AK.
2 weeks.
Counsel, the petition is present. No representation for the respondent. This is matter after 2 weeks. Yes, 34.
Cell number 34,
Counsel for the respondent.
Ramaya Gowda.
Counsel for the petitioner, may not kindly pass over. This matter could be taken up, my lords, with the third
This
matter.
is matter after 2 weeks.
Stays there, may not
And
kindly
talks for the
extend the
petitioner.
stay. My lords, next, the date will be fixed next week.
List this matter on 10th.
Obliged.
10th.
Stay
The
may be
request of
extended.
non-counsel the petitioner. Look at it. If interim order is there, extended till then.
Yes.
Then 35.
Cell number 35, Geeta Devi, MP.
For the appellant,
35.
my lord, in this matter, we have filed a petition for with regards to order 7 to 11, my lord. My application was rejected because parent, mother, all the three of them are residents of Australia, my lord. Where, my lord, the father has moved I'm filing a memo. In Australia court with regards to GNWC custody matter, my lord, there is a final order has been granted where, my lord, the GNWC has become infructuous, my lord.
Eleven 2023.
Please, my lord.
So, in view of this order dated 11/9/2023, this petition becomes infructuous.
GNWC, which the father has been filed, my lord, that has become infructuous. My lord, the marriage was in 2013. After the marriage,
No, what is the order impugned?
7/11 was rejected, my lord.
Huh?
7/11 was rejected because we are sought for jurisdiction, saying that they are the permanent resident of Australia.
That
So
the court has no jurisdiction.
please, my lord.
That is rejected.
That is rejected.
Thereafter, final orders were passed.
No, my lord. Stay of further petition because we have filed this petition challenging the order. 7/11, my lord. So in view of further proceedings, the GNWC is still in pending, my lord. But now, my lord, meanwhile, to 23, the father has been now all the three are in Australia itself, my lord. Only for short period they came here. In meanwhile, by malafide intention, he has filed a GNWC case here. No, but in view of this, the GNWC has become infructuous, but he has not made an attempt to dispose. But in view of stay order, it has been pending, my lord.
What is to be done now?
So this petition may be allowed, my lord, because
No, please come to this whatever order that you have passed on.
Please,
What
my
is this order?
first page, my lord, where both have agreed for that. Para 2, my lord.
So before the courts at Australia, the order is passed with regards
Please,
to
my lord.
custody.
Please, my lord.
They are not residing in this.
No, my lord.
So there is nothing to be adjudicated now. That we will say. Why will I allow that?
Please, my lord.
The present writ petition is filed. Where is the impugned order?
Annexure Z, my lord.
Page number.
Page 95.
95,
my lord.
And the agreed with orders passed in I number 3 in GNWC number 120 of 2021, dated 3rd January 2022. The mother is before this court. Mother is before this court. The mother has filed this application under order 7 to 11 to reject the petition as not maintainable. The court by order impugned had dismissed the said petition, holding that the court has got jurisdiction to entertain the petition. It is when the matter came up for hearing, it is submitted that thereafter all the parties have moved to Australia.
Yes,
And before the Federal Circuit and Family Court of Australia Division 2, they have opted. They had an order. A final order was passed on 11/9/2023, and the custody was, and accordingly, custody was the rights of the parties were crystallized by the court. It is submitted that in that view of the matter, the petition filed by the writ petition needs to be allowed. Next para. There is no representation on behalf of the respondents. The heard the and counts for the petitioner and peruse the material non-record. When the parties have obtained an order from the courts at Australia, and already a final order was passed on 11/9/2023 with regard to the rights of the parties, and this court is not inclined to pass any orders, and no further orders needs to be passed in this petition, and accordingly, the writ petition is closed, and all the interim orders that are granted stands vacated.
Respondent wanted to state, my lord. Respondent wanted to state.
For the respondent, there is a settlement talks going on, my lord.
Some settlement which is ongoing here in the matter.
This is matter after 2 weeks. Submitted that the settlement talks are going on. 637.
Number 37, Prabhu Tumgi, Siddeshwara B.
For the petitions counsel, husband For example, my lord, the child is born now, he is about 14 years. And there is a divorce has taken place between the petitioner and the respondent, 2019. The child was in the custody of the mother.
What is the impugned order?
My lord, impugned order is the child has to be sent to psychiatrist for a psychiatrist to know the child's mental status. In fact,
That order,
you will
impugned
ask
order
kindly
is
turn to page number 20, my lord.
21.
20. IA number 20 filed by under section 26 of so and so, and all that is allowed. The child psychiatrist come, counselor, a doctor is appointed to ascertain the mental well-being and emotion of the child. The petitioners.
What compelled the court to pass this order?
The family court passed the order. Now there has been my lord,
The age of the child?
14 years.
14 years.
And he's studying, he's a 9th standard boy studying, comfortable very well. In fact, the difficulty and problem arose is the mother doesn't allow the child to talk to the father or allow to go. There are about 10 times orders came to be passed for the custody of the child. Never allow. And ultimately, the last order was there, my lord, he went to the house, the gate was locked from the inside, child says, I'm not coming. In fact, the child was brought before this honorable court, my lord, and he was questioned. And judge passed an order, child is ready to go to the father also. That order is there. If time permits, can even summon the child also and see. This is the manner it is taking place. Being the father is unable to.
We'll just see
Yes,
what made the court to pass this order. Read from point number 7.
Yes,
That's, para number 7.
7. Yes, ma'am. The relationship is admitted. It is not in dispute that the marriage of the petitioner and the respondent was dissolved in MC number so and so. It is an undisputed fact and that the child is under the care and custody of the respondent mother. According to the petitioner, it is the respondent who.
So what is the present situation? The boy wants to come to the father.
No, my lord. My lord, even after, my lord, what are the facts senior counsel has stated? After that, my lord, he has filed an application before the vacating court, in the trial court. There the child was summoned. Child was interrogated. Interaction with the child was taken place with the judge. My lord, he specifically states before that he doesn't want to meet the father because after 10 long years, he has appeared before in his life and he has an exams to attend. Even on the exams day, my lord, he would file an application stating that he need for a birthday. All those things has been created, my lord. My lord, this application was filed by me, stating that how child psychology has been affected due to these proceedings. I am not interfering. I am not saying that I am not going to send. It's
why. How are you agreed by this order? It would be in your interest.
Yes, my lord.
Perhaps I may give up the claiming. If this is the way the child is allowed to go there, my lord, I am only disturbed because he's 14 years. His mind may be unnecessarily disturbed. Not that I refuse to do it. Last may kindly see, ultimately the quarrel between the father and.
It is like this.
Sorry?
According to the mother,
yes.
she is not like.
Restraining, my lord. Child himself, my lord, I stated before the judge.
I have several photographs.
My lord, I'll bring the order sheet.
Please understand.
Sorry.
No, according to the mother, that she is not coming in the way of the child meeting the father. That is the case of the mother. According to you, the child is somehow trying to influence him and see that the child does not meet the father. So now the court nor anybody can understand what exactly is happening to the child. Now going to a psychiatrist or going to a medical help is not something, a kind of an inability. Nowadays, brain is also part of its organ in the body. How it is working, only the professional can know that. There is nothing wrong. If the mother is trying to impress him or trying to make him, take a different way towards the father, the doctor will say it will help the relation to grow.
Yes. For that purpose alone, you will have to even summon the child and speak to the child and know it is not psychiatrist. Not that I'm worried of going to the psychiatrist. The boy should be sent there. Reasons are nowadays, the things are much more.
You said he has come before the court.
Yes, my lord. Yes, there were two petitions.
Father has come, child has come to this honorable court met the judge.
No, where is that? Anything was recorded?
My lord, serial number 8 is also pertaining to the same case. In serial number 8 also child was summoned.
See that?
Serial number 8 also. My lord.
Please view that. So was it recorded by the litigant?
Yes, my lord.
What did he, what
My
was
lord,
recorded?
initially the child said he doesn't want to interfere.
Can
In
you
serial
list
number
this matter day after tomorrow?
Please,
Let both the parents along with the child be present before
my
the
lord, have it on any Saturday. My lord, child has school. Difficulty is that, my lord, any Saturday
What is
chamber
that
conciliation.
what are you saying? Saturday, why the court will sit for you?
No, my lord, a chamber conciliation for the child, my lord, that's it.
If you don't want, the court can't help it.
My lord, we want, my lord, but the difficulty is he has school.
How can it be? How can you expect the court to sit for you on Saturday?
In that case, my lord, my submission is after 4 o'clock, my lord.
That's what it will be, 5
Please,
o'clock.
5 o'clock, please, my lord. I'll bring the child.
Yes.
5
Oh, list this matter on day after tomorrow at 5 o'clock in the chambers, and
Please.
both the parents along with the child shall be present.
Please.
Yes, next.
List number 2, parted matter, serial number 1, Harish Bhandari.
Sorry, my lord. There is serial number 8 is also there.
List along with serial number
Along
8.
with that.
Please. Yes.
One submission, serial number 23. I was held up in Kotal 11. By the time I reached, date has been given 22nd, 27.
23.
20,
Take out that bundle, 23. Yes, next.
1 and 20.
Yes, now one parted matter.
Yes, ma'am. List number 2, parted matters,
Respondent.
serial number 1, Harish Bhandari.
Require some time, my lord. Some.
List this, delete from parted. List this matter.
My lord, this is actually, my lord, covered by judgment of the coordinate bench.
No, man.
Yes,
There is a Supreme Court judgment.
fully
It is
covered-
not properly
fully covered.
There is a Supreme Court judgment.
This is before the bench having roster.
My lord, your lordship may request, my lord, for a date.
List this matter before.
Thursday,
the-
my lord.
No, not Thursday, just so the court has reopened on 11th June.
11. Serial number 2,
My lord,
Harish Bhandari.
It
Same.
could be
Both are
10th or
connected.
12th. my lord. 10th or 12th.
12th.
12th. Great.
Same
Yes.
connect. List serial number 2.
Next matter.
2 also same. 12.
Serial number 3. Serial number 3.
Appeal for the respondent number 1 to 4, my lord. We have filed a MFA, my lord, 380 of 23 for the enhancement, my lord. Therefore, it can be clubbed, my lord.
Give that. Who appears for the, you appear for the
Respondent number 1 to 4, my lord.
I think last time all these are under parted because
Some settlement there.
they were referring to some settlement.
Please, my lords.
Uh.
My lords,
What is the
last
amount?
occasion.
No. You are seeking enhancement of the compensation.
Please, my lord.
What was the amount granted? Let us look at it.
20 lakh 14,500, my lord.
Petition entitled for compensation of rupees 19,95,000.
99,500.
On what ground you are seeking enhancement?
Lords, we are for the corporation, my lords.
Your- Oh, your corporation is before
Please.
the court, yes.
My lords, on the last
My lord, on the
occasion.
last occasion, it was pointed out, my lord. As per exhibit P13,
Hmm.
the salary is 9,868, my lord.
9,000?
9,868. And if 40% is added to that, my lord, it will come to 13,815, my lord. And the compensation will get reduced, my lord, from 18 lakhs,
So
14,500.
please come to the discussion part, how the court has calculated.
Letter. My lord, its salary certificate is discussed at page number, para 12, my lord. Para 12. My lord, para 12, the last 3 lines, my lord. The PW2 is not cross-examined by the counsel for the responding corporation. Exhibit P15 salary slips reveal that the deceased was drawing gross salary for the month of April 2018 is 14,701. During the month of May 18 is 10,972. And during the month of June 2018 is 9,868. And it takes,
So
my
the
lord,
court had
average.
taken, the salary was 14,701.
Yes, my lord. And by taking the average, my lord, of 3 months. But the accident took place, my lord, in the month of July 2018, my lord. So therefore, what was prevailing, my lord, in June should have been taken, because June is 9,868, my lord.
No, but April is getting 15,701. May 2018 is 10,972. And June is 9,868. Rightly taken, average of the three, because it keeps on varying from
My
month
lord,
to month.
not so much, my lord, because it won't be from 14,000, it gets reduced to 10,000 the following month, my lord. In April, it was 14,000. Then, my lord, in May, it was 10,000, my lord. It should increase, my lord. All the other.
But why it is happening, it's for you to say. RTC has to say why they are giving 1 month 14,000, other
But
month,
it is the workman, sorry, the claimant has not explained, but it is his own, what is being discussed is by his documents, my lord. He has produced the documents.
We'll take 11,000 as salary, but
Lord,
not 12,000.
But we're seeking for the enhancement in 380, my lord, in MFA number 23.
11,000.
There is another appeal of yours.
We have filed another appeal, my lord, for enhancement in MFA 380 of 23, my lord.
List this along with so and so, then automatically that will go. We can call it after also. Now, there should be some rational straight away, like 14,000, 10,000, 9,000 is what taken. We will take 11,000.
Yes.
And if it is on other grounds, it's a case of death.
Yes, it is.
So if on other grounds, if you get, we'll just calculate like that. If you take 11,000 as salary, future prospects at what, for 50% it should be taken.
Well, at 40%.
40%, yeah.
Well, 110 into 40 is type 110.
4,400 would be the future prospects.
4,400.
Then it comes to 15,400.
400.
And
Bachelor, huh?
how many are the dependents?
4, my lord.
4.
No.
How much 1/3 has to be deducted?
Well, the
1/4, my lord.
1/3 has been deducted, my lord.
Hmm.
1/3.
It comes to 5,133.
133.
My lord, it has to be considered 1/4, my lord.
Huh?
1/4 deductions. 4 members are there.
ಇಲ್ಲಿ 1/4 deduction ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? No.
4 to 6, 1/4.
My lord, it's half of my lord.
He is unmarried.
Unmarried, my lord.
Unmarried, my lord.
And then
That's
it
for
has to be
50%, my lord.
It has to be half if it is unmarried.
Please,
So 11,000, half of it is 5,500. 5,500 into 12, what is the multiplier?
18 million.
No, sorry, it is 15,400 minus it is 7,700. 7,700 into 12 into
18 million.
it comes to 16 lakhs 63,200. Claimants are
My lord, one second.
one
ಅಲ್ಲ ಅವ್ರೇನ್ ಬ್ರದರ್ಸ್ ಏನು ಅಂತ
two brother sister 4 or
mother, father, and brother and sister.
parents
So-
and siblings. My
so
lord.
44 into 4 it comes to 1,76,000. 36,000 and 10,000. Yes.
ಸ್ವಲ್ಪ ಕಮ್ಮಿ ಆಯ್ತು ಅಷ್ಟೇ.
It comes to 18,85,200. How much is granted?
19,99,500.
90?
19,99,500.
That's how it would be.
Yes, ma'am.
We'll call for that also, that in the afternoon or tomorrow, call for the, what is that, it is submitted that. So and so,
380 of
the claimant has filed MFA number so and so. After obtaining necessary orders, list that matter along with this tomorrow. Yes,
Cell number 4.
pin that calculation.
Palakshaya. Cell number 4, Palakshaya.
Yes.
Sridhara K.
Okay, for respondent number 1.
Huh?
Respondent number 1.
What about that? Any calculation is made, look at it.
They have challenged only for dependency.
Put down.
Yes,
If it is Mr. Palakshaya, because the files have been taken from him, my lord, and it's been distributed. My lord, can I see the file and submit? my lord?
List is matter tomorrow.
Yes, my lord. I'll seek instructions. by him.
Yes, list is matter tomorrow. Give the file to her so that she'll have the
Yes, ma'am.
benefit of looking at it. Yes, 5.
Cell number 5.
What about this?
My lord, he's been taking time. My lord. Kindly see the order sheet. Matter has been, my lord, at this instance, he said his senior was out of station. Twice, my lord, it has been heard, my lord, and his, if your lordship could see the order sheet, my lord. He's been taking time, my lord. My lord, in this case, the point is, my lord, that the claimant is 32 years. He says, my lord, he was an
Heard the
advocate.
land counsel for the appellant in part. There is no representation on behalf of the respondent.
Then he came, my lord. Second time he came and so sought for time.
Matter after summer vacation. Why do you want time now?
My lord, now stage for my lord,
Huh?
my lord, delay application may be allowed, my lord.
That anyone will allow.
But kindly have the matter on next week, my lord. Date may be fixed.
Oh, why, where is this partner? It is not there. When did the court say partner?
My lord, he was an advocate, my lord. If your lordship
Oh,
could.
appellant in part, there is no representation as partner. Yes. Delete this matter from partner. IA number 1 of 22 is filed to condone the delay of 100 days. Condone, admit, post for final hearing. Call for the TCR. Yes, next.
Cell number 6. Ravi Shankar CR.
Appellant, my lord.
Yes,
What is
Rajshekar.
This is the application filed for the LRs of deceased mother, your lordship. And they have to come on record and is your lordship allowed the application.
Yes,
There is no delay.
There is no delay is also filed any application.
Huh?
It has to be allowed and then it is already made a party to the proceedings in the appeal.
No. When he died, when did you file this application?
I have produced the document. Your lordship.
Where is that? Where is that? Look at it. You appear for them.
For respondent number 2, my lord.
You appear
Case
for
ID.
respondent
Yes,
number 2.
Yes, ma'am.
IA number.
Read on 9/7/2021.
How can you maintain an IA of 1 for all these applications? It can't be. They should be.
Because they raised the objection because that's why set aside and bringing the LRs and also.
There should be separate IAs for everything. You can't file one IA. There should be an IA to set aside, so one IA to condone, one IA to restore.
3 IAs has been filed, your lordship.
No, you filed only one IA.
No, your
All
lordship.
reliefs in one
9(3)
IA.
and
The
here only.
petitioner shall come up with appropriate appellant shall come up with appropriate application. Yes, next. Delete this matter
Application.
from partner.
5 applications also filed, your lordship. Application under 5, bringing the LRs also filed, memo filed. And LRs of the application.
There is a procedure for everything. We can't give by to all that.
And separate application has to file, your
But
lordship.
for everything, there should be an application. IA 1, 2, 3.
Yes, yes.
Yes.
He will file it, your lordship.
Yes.
Now, may I make one request, my lords? Now,
2 weeks, your lordship.
now, my lords, since he has filed, my lord, single application seeking for 3 reliefs, So this IA may be disposed of with liberty to file, my lords, separate applications.
I number 1 of 23 is filed to condone the delay, to set aside the abatement, and to
Bring the LRs.
bring the LRs of the deceased on record. The petitioner cannot, the appellant cannot come up with so many reliefs in one petition, and accordingly, I of 1 of 23 is dismissed, giving liberty to the
To file the fresh
appellant
application.
to file separate IAs
Yes.
for all the 3 reliefs.
Yes, Your Lordship.
Yes.
I'll file it.
Number 7,
I appear for
Chandrasekhar
respondent. I appear for respondent.
Please.
7 and
Lords, this
Seven
was,
and-
my lords may kindly recollect, my lords, just before vacation, these 2 matters are, my lords, settled in Lok Adalat. Then since, my lords, last working day, my lords, it was on last working day, my lords posted this matter to today, my lords.
He was asking adjournment in the morning.
7 and 8. 7 and 8 maybe.
Why adjourn? Why to adjourn? We can pass orders if you argue.
Some
Simple issues, what are so complicated in this?
no complicated. My lord, future prospect is to be considered in the serial number 7. A 22 percentage
We'll
of
hear it.
disability is there.
Hear it.
Judgment is not available with me.
I number 1 of 23, I number 1 of 23 is filed. To condone the delay of 139 days in filing the appeal for the reasons stated. The delay is condoned. Delete from part 3rd, list before the court having roster. 7 and 8 both.
8 is also is some cross examination is in Kannada. my lord.
9,
Agent.
Please.
Grateful.
Yes, 9.
9,
For the appellants, my lordships. My lordships, case of injury, my lordships.
Memo is filed seeking dispensation of notice to R1. Notice is dispensed with. List is delete from part 3rd and list this matter before the court having roster. Yes, next.
cell number 10, 10, Shruti SP.
This case, I am for the respondent for corporation. In fact, last time we had proposed some amount. Last time also they had not come.
Representation for the appellant, list this matter tomorrow? Or you want let it go before the court?
Yes, madam.
The
Because
no
I don't think
representation
tomorrow.
for the appellant, delete from part 3rd and post this matter before the court having roster.
Much
Next 7.
Cell number 11,
For respondent,
Sachin BS.
for respondent, Your Lordship.
For the petition, my lords. Lords, if my lords recollect, my lords, this RPFC, my lords, I was directed to pay, my lords, 6 lakh of arrears to the respondent, my lords, which was paid. Thereafter, my lords, they filed execution, my lords, in spite of paying the amount that is before this court. My lords had stayed the execution, my lords, before the trial court. Lords, now this has come up, my lords, for final hearing. Lords, a short question of point, my lords.
Kindly grant me 2 days time, sir. I will come before the court. Your Lordship.
This
I am
is
for
matter.
respondent, 2 days time maybe.
Delete from part 3rd, list this matter for the court having roster. Yes. Any for password matters? Call that. Yes.
Pass over matters. Cell number 8.
That 8 is coming up along with some other matter.
Yes.
What is that? When is it listed? It's coming up day after tomorrow.
11. This was 12, madam.
12. Only 12 is left. 8 is along. Then call 12.
Shall I permit you?
How much is the amount?
Out of the 2,40,000, I have paid 1,27,000. The due amount, till now, there is a 2,40,000, Your Honor. Out of that, I have paid 1,27,000. 1,13,000 is balance amount.
1 lakh?
13,000. 1,3.
How much you are going to pay now?
I paid the 40,000.
Pay 60,000.
50,000 maybe. Because
First of all, your matter cannot be entertained for the reason.
in CMIS number 181.
Can't bargain for that.
Highly
The
obliged.
present
50,000
petition is filed. Present petition is filed seeking to quash the order dated 4/5/2023 in criminal miscellaneous number 393 of 2020 passed by the 4th Additional Principal Judge Family Court Bangalore in I number 2. and also to set aside the entire proceedings in criminal miscellaneous number 24 oblique of 2024 on the file of the fifth additional principal judge, Family Court, Bangalore. It is submitted that the court had granted maintenance of an amount of rupees
10,000.
10,000.
Yes, every month of 7th.
10,000. You said 15,000 in the morning.
No, 15,000 in DV Act.
10,000. And it is submitted that the court has also in DBC has granted an amount of rupees 15,000. And now the execution proceedings are filed by the respondent in spite of the fact that he has been paying the substantial amount. It is stated that from the date of order, he has to pay an amount of rupees 2,40,000, and out of that he has already paid 1,27,000, and the outstanding balance is 1,13,000. It is submitted that he is ready to pay, the petition is ready to pay an amount of rupees 60,000. Is ready to pay an amount of rupees 60,000, considering the submission of the land counsel of the petitioner. This court, hence, there shall be stay of all further proceedings in criminal miscellaneous number 24 of 2024 on the file of the fourth additional principal judge, Family Court, on the condition that the petitioner shall deposit an amount of rupees 60,000 within 3 weeks from the date of receipt of the copy of the order, or else the stay granted by this court stands vacated. Notice to respondent.
One submission in this case. Shall I deposit the amount in a main case, Your Honor?
Huh?
Shall I deposit the amount in main case? CMS 390.
Deposit the amount before the trial court and not in the main case, in the execution case.
Yes,
and on such deposit, the respondent is at liberty to withdraw.
Kindly grant 4 weeks, Your Honor, at least
4 weeks. Yes.
Then
What
number
about that
20
matter?
23.
highly obliged.
Yes.
23.
How much is
Serial
the amount granted?
They've dismissed it. That's what I agreed by the order. I filed an application under section.
The respondent. Notice to the respondents.
Much obliged.
Court officer. Court officer. Court officer.
ಏನ್ ಬಂದಿಲ್ಲ ಇನ್ನು ಮೇಡಮ್ ದಯಾಸಿಂಗ್ ಇಲ್ಲದೆ ಇರಲ್ಲ ಇದ್ರೊಳಗಡೆ ಪಾರ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಆಗಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಅಲ್ಲಿ ಮೇಘಾಗೆ
Court officer. Court officer.
ಸರ್ ಹೇಳಿ ನೀವು ಇನ್ನು ಮೇಡಮ್ ದಯಾಸಿಂಗ್ ಇಲ್ದೇ ಇರಲ್ಲ ಅಷ್ಟು ಬೇಗ ಕೋರ್ಟ್
ಇಲ್ಲ ಅವ್ರು ಹೋದ್ಮೇಲೆ ಹೇಳಿದ್ದು ಬಿಡಿ.
ಸರ್ ಅದನ್ನೇ ಮೇಡಮ್ ಇಲ್ದಾದ್ಮೇಲೆ ಪ್ಲೀಸ್ ಯಾವಾಗ್ಲೂ ಅಷ್ಟೇ ಇಲ್ದಾದ್ಮೇಲೆ ಕೇಳಿಪ್ಪ.
ಮೇಡಮ್ ಅವ್ರು ಹೋಗೋವರೆಗೂ ವೆಯ್ಟ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಬೋಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 8 and 9 ಏನಾಯ್ತು ನೋಡಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಯಾವ 8? ಸೀರಿಯಲ್ ನಂಬರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲ?
ಅದೇ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ
8 ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು?
9.
9 is also released from parted.
ಬೇರೆ ಏನು ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ
ಮೇಡಮ್ 10 ಏನಾಯ್ತು ಮೇಡಮ್? ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10.
ಮೇಡಮ್ ನಿಧಾನಕ್ಕೆ ಕೇಳಿ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
ಒಂದ್ ನಿಮಿಷ ನಿಧಾನಕ್ಕೆ ಹೇಳಿ. ಏನ್ ಹೇಳ್ತಾರೆ? ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲ ಎಷ್ಟು? ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಮೇಡಮ್.
10 ಲಿಸ್ಟ್ ನಂಬರ್ 2.
10 ಮೇಡಮ್.
ಅದೇ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನ
ಎಸ್ ಮೇಡಮ್.
ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟೆಡ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲ ರಿಲೀಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆಯಾ ನೋಡಿ ಕೋರ್ಟ್.